Good afternoon, everyone, and thank you all for joining us for this criminal record expunction Listen and Learn. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. If you are unfamiliar with the format of this event, first we're going to watch an informational video on this area of the law. At the end of the video, we will have a question and answer session with one of our second chance attorneys. You can put your questions in the Q&A box on Zoom or in the comments section on Facebook at any time. We'll review all questions put in the chat boxes during that Q&A session. Please remember that this is a public forum and legal aid is not representing you. So please remember not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to start the video. Give me just a second. This presentation was created by Legal Aid of North Carolina. This presentation only provides legal information and not legal advice. The information presented is based on North Carolina law only.
What is an expunction? Expunction means to permanently remove an offense or a conviction from a criminal record. When an expunction is granted by the court, the public criminal record of the expunged offense or conviction is destroyed. Once somebody receives an expunction, they can truthfully deny that the expunged offense or conviction ever occurred. There are three primary types of expunction. There are the expunction of not guilty charges, the expunction of dismissed charges, as well as the expunction of convictions. We will review the three types of expunction. We'll start with the most common types of expunction, and then we'll get into the expunction of convictions. So the first type is the expunction of not guilty charges. Now, these are all charges where someone was found not guilty of the offense that they were charged with. These types of charges are eligible to be expunged. Next is dismissed charges, and these are all charges that were dismissed. These are also eligible to be expunged. Now, most charges that are dismissed after December 1st, 2021 will be automatically expunged 6 months after they are dismissed. However, if somebody has dismissed charges prior to December 1st, 2021, they will need to file a petition to seek the expunction of those dismissed charges, and those types of dismissals will not be automatically expunged. All of that to say, if somebody has dismissed charges that were disposed of prior to December 1st, 2021, they are still eligible to be expunged. That person would just need to file the petition and file it with the court to seek that expunction, as opposed to most charges that are dismissed after that December 1st, 2021 date. Those will be automatically expunged from that person's record 6 months after the disposition. Now, let's talk about the expunction of convictions, and these are where somebody was found guilty or pled guilty to an offense that they were charged with. There are two categories of this type of expunction. There are what we call youthful convictions as well as adult convictions. Youthful convictions are also known as raise the age convictions. Now, these are most misdemeanors and some Class H or I felony convictions that were committed before December 1st, 2019, when the person was 16 or 17 years old at the time of the offense. These types of convictions are eligible to be expunged. Adult convictions. These are some misdemeanors and few felony convictions when someone was 18 years old or older at the time of that offense may be eligible for expunction. Now, there are a number of what we call disqualifying convictions that could prevent somebody from expunging any of their adult convictions. Now, the law that speaks to the expunction of adult convictions includes a list of offenses that are not eligible for expunction, and the statute that speaks to that is listed on the screen. Now, if somebody has a conviction for any of these types of offenses, that person is not eligible to expunge any convictions that occurred when that person was 18 years old or older. However, that person may still be able to expunge any race to age or youthful convictions that they may have, and they are also still eligible to expunge any dismissed or not guilty charges that they may have. Some of the most common ineligible offenses include Class A through G felonies, such as common law robbery or the sale of drugs. We have Class A1 misdemeanors. The most common ones that we see are misdemeanor child abuse. Domestic violence protective order violations are also Class A1 misdemeanors. We have any convictions that require sex offender registration. We have assault offenses, so any offense where assault is an essential element of that offense. So, as on the screen, assault on a female, simple assault. If assault is in the name of the charge, it's likely going to be disqualifying. We have any offense that involves heroin or crystal meth. And then we also have possession with intent to sell or deliver cocaine, which we abbreviate to be PWISD cocaine. And this differs slightly from any felony offense involving heroin or crystal meth, because mere possession of those types of drugs is disqualifying, as opposed to cocaine, where felony possession of cocaine is not. There needs to be some further intent with cocaine in order for that to be disqualifying. And again, these are just the most common. There are a couple more on that list, but all of that to say, if somebody has a conviction for one of these types of offenses, what that means is that they are not eligible to expunge any adult conviction that they have on their record. Now, I'm going to walk through what the general expunction process looks like. This can vary in time, meaning it really depends on a multitude of factors how long this process can take. But generally, no matter what type of expunction someone is seeking, the process will look generally the same. And so the first step is obtaining an accurate and complete copy of the criminal record. In order to be able to move on to step 2, which is determining eligibility for expunction, somebody needs to make sure they are reviewing an accurate and complete copy of the criminal record that they are seeking to expunge. And so once somebody has that complete record, they can move on to step 2 and determine, based on what is on that record as it applies to the law, what may or may not be eligible for expunction. Now, step 3, if it is determined that someone does not have any offenses that are eligible for expunction, the process stops at this point. There are no further steps to be taken. However, if it is determined that somebody does have offenses that may be eligible for expunction, we continue on to the next step, which is to identify the correct petition form for that type of expunction. There are separate petition forms for each type of expunction, and these are standard forms from the Administrative Office of the courts. And so depending on the type of expunction relief somebody is seeking, there is a specific form that that individual would need to complete in order to get that process started. Now, once somebody has identified the correct petition form based on the relief they are seeking, they would want to complete it and any required documentation that may be needed depending on the type of relief they are seeking. That to say, when it comes to expunging convictions, there are supporting documents that are needed in order to support the expunction, and so that individual would need to not only complete the petition form, but also want to complete those documents and file those with the court at the same time. Once all of the petitions have been drafted and all of the supporting documents have been completed, the next step is to identify and follow any county-specific procedures for filing. And what that means is there are 100 different counties in North Carolina. And so there are 100 different ways that somebody could go about filing the petitions in the counties that they need to file in. And so depending on the counties that somebody is working in, they would want to reach out to that clerk's office to inquire about how best to get their paperwork filed as needed. Now, to this point, petitions for expunction need to be filed in the county and division where the expungable offense occurred. And what this means is, for example, if somebody has dismissed charges that are eligible in Wake County and Johnston County, that person would be completing at least 2 different petition forms, one for the dismissals in Wake County and one for the dismissals in Johnston County. Now let's say in Johnston County that person had dismissals in Superior Court as well as District Court. That person would be filling out 2 different dismissal petitions, one for Johnston County District Court and one for Johnston County Superior Court. And so when we say they need to be filed in the county and division where they occurred, that is an example of what that may look like. And so if somebody has a record that spans different counties and different court divisions, depending on the relief they are seeking, there could be a number of different petitions that need to be filed. Now, once somebody has filed all of the expunction petitions that they have worked on and are waiting to hear back from the court, again, how long that takes can vary county to county. But ultimately, by the end, that individual should receive the expunction petition that they filed, either denied by the court or hopefully granted by the court. And if the petition is granted, that means the expunction was granted by the judge. And so if somebody receives a granted order from the court, what they would want to do at that point is to verify that that expunction was certified. And what does that mean? There are public terminals in each courthouse where somebody can input their information to confirm that the expunged offenses no longer show up in that database. And that is the ultimate goal, because if somebody were to type in the file number of the expunged offense, it should no longer show, meaning that the clerk, upon the granting of that expunction from the judge, has gone into their system and deleted reference of that expunged offense from the public database. Now, to that point, again, to reference back to the beginning of this presentation, expunction means to remove the public criminal record of an offense or conviction. And so to that end, there are still certain agencies that are still able to access expunged records. However, as I will get into in the next slide, they can only access them for very specific purposes. So access to expunged records. These expunged records can still be accessed by prosecutors. So these are district attorneys. They can still see and use expunged records for sentence calculations. So meaning if somebody were to be charged with another offense and they are subsequently found guilty or plead guilty to that offense, district attorneys can look at expunged records that person may have had in the past and can use those when it comes to determining the person's sentence for that new offense that they were found guilty of or pled guilty to. Additionally, they can also use it for what we call habitual offender status. So again, it's kind of the same concept. If somebody is charged with another offense, plead guilty, found guilty, district attorneys can use the expunged offense to determine if somebody should be classified as a habitual offender. The next entity that can see them are arresting agencies, and that is because they keep what are known as investigative records, and the database that they use is not available to the public. And so if somebody doesn't work in an arresting agency, they're not able to see or access those records. And so they are not required by law to delete expunged offenses from their investigative records. And one of the main reasons is because it's not publicly available. And last, we have law enforcement agencies, and they can see expunged offenses and records for employment purposes. So if somebody is seeking to become employed at a law enforcement agency, that agency can see expunged records if that is the case, if that person has any of those. And then additionally, for certification purposes. And so if somebody is looking to obtain some kind of certification within the law enforcement agency, they can also see expunged records for those purposes as well, in determining whether, somebody should be hired or if somebody should receive that type of certification.
This presentation was brought to you by Legal Aid of North Carolina. Legal Aid of North Carolina is a statewide nonprofit law firm that provides free legal services in civil matters to low income people in order to ensure equal access to justice and remove legal barriers to economic opportunity. Legal Aid of North Carolina offers listen and learns on several topics, including criminal record expungement, child custody, Medicaid rights and eligibility, simple divorce, Social Security disability, SNAP benefits, tenant rights, and wills and powers of attorneys. And now that the video has ended, we will begin the Q&A session. Today we have Lorena Evans to answer those questions for you. Please remember that while Lorena is an attorney, she is not your attorney. She cannot respond to specific legal questions. So if you have a question, you can either type it in the Q&A box on Zoom or into the comments section on Facebook. I see a question asking, not I think that's something I can put in the chat. Those really aren't questions. They're again, someone's asking for clarification on that assault being something like assault on a female, or maybe it was some sort of simple thing,
Yes.
being a disqualifying. Just kind of clarify that assault.
Yeah, absolutely. So essentially, one of the alienated types of convictions under North Carolina law that governs what can and cannot be expunged is if somebody has a conviction for an offense that involves assault as an essential element. And so the easiest way to spot those types of offenses is if the word assault is in the name of the offense. And so things like simple assault, assault on a female, assault with a deadly weapon, any offense like that would be disqualifying. And the determining factor is if somebody was convicted of that type of offense. And so if somebody had a simple assault charge that was dismissed, that wouldn't be disqualifying because it was dismissed. And so really, when looking at eligibility in terms of whether somebody may or may not be eligible to expunge their convictions, we're looking at how was the charge disposed. And so if somebody has a conviction for that type of offense, that is what makes it disqualifying.
Gotcha. Hold on. Next question. Okay, that one was answered. What are the wait times from when like how long do you have to wait from being convicted to be able to potentially start the expunction process?
Yes, that varies depending on the type of conviction somebody may be eligible to expunge, as well as how many convictions. And so this part gets very tricky and very intricate when it comes to looking at the law. And so we would recommend if anyone believes that they may be eligible to expunge their convictions, that they reach out to an attorney to see if they can get some assistance with that, because there are a lot more steps and a lot more things that need to happen in order to petition for the expunction of convictions. But broadly, there are 5 different types of waiting periods, depending on, again, like I said, the type of conviction and how many. And so, broadly, for a single misdemeanor conviction, it would be 3 years from the date of that conviction, so long as any sentencing for that conviction was completed within that 3 years. If not, the sentence would have to be complete before someone could file for the expunction. For multiple misdemeanors, it is 7 years from sentence completion of the most recent conviction, whether or not it is or is not one of the misdemeanors. For a single felony, it is 10 years from sentence completion. For a single breaking and entering felony, it is 15 years from that sentencing being complete. And then for up to 3 felonies, it is 20 years waiting period. And those 3 felonies must have occurred within the same 24-month period. And so essentially, you could only possibly expunge up to 3 felonies. And, if that is the circumstance, then those 3 felonies would have had to have occurred in the same 2-year period. So it depends on, what someone may be eligible for. And as, you can probably guess, just based on the numbers I just went through, that it can get complicated very quickly. So, like I said, I would just recommend reaching out to an attorney if possible, if you think that is something that you might be eligible to do, to get some guidance on how to go about doing that.
Perfect. If someone has multiple dismissed charges, like it's the same charge, I guess they've received that charge multiple times, but they were always dismissed, can all those dismissed charges be put on one petition? And then second part of that question is asking if there's a different kind of charge that has also been dismissed, can that be added, or you have to do each individual charge? And if
Hmm.
not, does it have to be each individual type of charge? I think is what the question is asking.
Yeah, that's a great question. So essentially, when looking at how to file, like complete a petition, you're really going to want to make sure that all of the charges were one, disposed in the same way. So for that example, if somebody had 10 dismissed charges, they all were dismissed in Wake County District Court, that person wouldn't need to file 10 separate dismissal petitions because they all occurred in the same county and the same court division. So long as they were all dismissed, that person could put all 10 of those charges on the same petition form. And the same goes for if somebody had multiple not guilties in the same county, in the same court division, those could all go on one form, and so on and so forth. So long as the case was disposed in the same way, it is eligible to be expunged, and it happened in the same court and the same county, then they can all go on one petition, and that person doesn't have to file individual petitions for every single charge. Um, that would be a way to inundate the court system. And so long as it's in the same area, they can all go in the same form.
Perfect. Um, Say someone now has a married name. When they're filling out paperwork, do they need to use both their maiden name or just their current last name, or how does that work in terms of being able to fill out the paperwork correctly?
Yes, usually in that circumstance, what we do for any individuals, any clients that we're working with that may have maiden names or aliases, we will put what the client's name is currently, and then we would put AKA and list any of the other names that they have records under. And then that way, it's just so the clerk and the judge knows that this is the person's name now, but the records are under this name or these other names. And so I would put name now, AKA, and then any other names that the records are under.
Perfect. And then for those of you who have your hands raised, you cannot unmute in this forum. If you have a question, you need to type it into the Q&A box on Zoom or put it in the comments section on Facebook. Okay. Have a couple people asking, one, is a lawyer required for an expunction? And two, is there any way legal aid might be able to help?
Okay. Great questions. One, is a lawyer required? No, not necessarily. We would just recommend, if you think that you may be eligible to expunge your convictions, that, if you would like to see if legal aid can assist you, I would definitely recommend applying for our services to see if you may qualify. That is just because there are a lot more, like I said, a lot more steps that go into that. You can only really file for the expunction of convictions one time, as opposed to for dismissals or not guilties, or raise the age eligible under 18 convictions. You can file as many petitions as someone needs. But when you're expunging adult convictions, you really only have one shot of doing it and capturing all of the eligible convictions. And so, because there's a lot more at stake, if it's at all possible, I would recommend contacting an attorney. But for dismissals or not guilty charges, those are a lot more simpler to file, just filling out the paperwork and taking it to the applicable courthouse clerk's office. And so I don't think it's required, but for most things, if you're able to get an attorney, that would be recommended. And in terms of reaching out to see if legal aid can help, what we are doing at the Second Chance Project is opening our intake for applications the first full week of every month. And so it just so happens that the Listen and Learn falls on the first full week of February. And so our applications are currently open. So I would direct you, if you are able to, apply online with our new online application justice hub. And that way, your application will be reviewed. And if you qualify for our services, we will be able to open a file and we'll take a look and see what we may be able to assist you with at that point. And so since applications will be open until Friday. If you're at all curious to see if you may qualify, I would definitely encourage you to apply. And if we're able to open a file, we'll take a look and see what we may be able to assist with.
Perfect. And I have put a link to the Justice Hub. That's how you would like, if you are looking for services from legal aid, the best way is to apply via our new Justice Hub, and the link to that is in the chat. Um, can someone file for an expungement, expunction while they still have ongoing charges?
It depends on what type of expunction. Someone can file to expunge their dismissed charges or not guilty charges, but having ongoing current pending charges would prohibit somebody from petitioning to expunge their convictions. And so, just as a recommendation, it may be best to wait until those pending charges are resolved before proceeding with an expunction. Just to, depending on how that case is disposed, then you could just take care of all of the eligibility at one time. But theoretically, someone could file to expunge their dismissals and not guilties, and possibly raise their age convictions if they have any, even with ongoing pending charges. It would just be adult convictions that they wouldn't be able to pursue.
Okay. For those of you asking specific questions about whether or not specific charges can be eligible for expunction, we cannot respond to those in this forum. That is a little too specific. Remember, this is a general information, listen and learn. Um, is there a specific form that I guess a moral character letter needs to be completed on? I'm assuming you know what those are.
Yes, I'm gonna guess that's referring to the like character affidavits that are required for expunging adult convictions. So on top of the petition itself, there is a petitioner's affidavit, which is a affidavit from the person petitioning the court for the expunction. Essentially, they're just kind of form documents that have the petitioner and their character affiants just attest that that person has met all of the requirements needed. And so there isn't a standard form. It is just kind of, we have one that we use here at Legal Aid that just is on one page. It literally just goes through the statute and, has the client and the affiants attest that all of their eligibility is met. And so there isn't a standard form. It's just going through the statute and making sure all of the requirements are met and that is in the affidavit to be submitted.
Perfect. Let's see. Oh, how much does an expunction cost?
Yep, great question. So it will depend on what type, again, on what type of expunction someone's petitioning to file. And so if someone's petitioning for their dismissed charges and not guilties, there is usually no filing fee. So most of the time, if somebody drafts a petition, takes it to the clerk's office, they should be able to do that, no problem, without being asked to pay a filing fee. Now, if somebody has a dismissed charge that was dismissed via some kind of conditional discharge or deferred prosecution agreement, meaning that, let's say, the DA's office offered for that person to complete probation for 12 months, and upon successful completion, they dismiss the charge, those are still eligible to be expunged, but there is a $175 filing fee. For expunging adult convictions, it will be $175 as well per petition that you file. And for raise the age convictions, I believe it is $52.50. Now, there is a form that someone can submit along with the petition that can ask and request that the court waive the filing fee based on a number of factors. If somebody is unable to afford it, if they are on some kind of government benefit such as SSI or food stamps, or if they're represented by an entity like Legal Aid, you can file a petition to proceed as indigent, which can allow the clerk and the judge to waive the filing fee for any of those petitions that require a fee. So it's going to depend on what type of petition, but there is a possibility that the fee can be waived.
Um, and you may or may not be able to respond to this. For convictions that are waived or prayer for judgment charges, how do they fall in the expunction world? Assuming you understand what those mean.
Yes, I do. So prayer for judgments continued are treated when it comes to expunction purposes are treated as convictions. And so if I was reviewing a record and somebody had a PJC is what we kind of abbreviate it to, then that would be considered for possible eligibility, depending on the record, as a conviction for expunction purposes.
Uh, and then I guess along those same lines, what about a pardon? Is something that's pardoned also expunged? I think is
That is,
that's what that question is asking.
I'm not sure if I even know the answer to that question because I don't think that's I've ever seen something I've ever seen that in a circumstance. So I unfortunately I don't think I can answer that because I actually am not sure. I'd have to look into
Gotcha.
it. Yeah.
No, no problem. Hold on. I think I skipped a question. What are some of the supporting documentation that someone should have when they're looking to file for so I guess what are all the more common documents that someone needs when looking at
Yes.
filing an expunction?
Yep. So like I mentioned earlier, for dismissals and not guilties, as well as razor age convictions, really, except for the petition itself, you may just need that petition to proceed as indigent if there is a filing fee. Those would be the only documents that you would need to be able to file that petition. And you'd be able to file it without the indigency form. You would just have to pay that filing fee. Where you will need more supporting documents will be when expunging adult convictions. And so under the law, along with the petition, the law requires that the applicant, the petitioner, also submit a petitioner's affidavit and two character witness affidavits, which I mentioned just a little bit ago, to support the expunction. And then again, the indigency petition to proceed as indigent as well to waive that filing fee. But really, it will be those core documents that you would need to file to complete the application to file for the expunction, and you would need that document packet for any county and any court division that you are filing to expunge convictions. So it may just be more than one depending on the eligibility of that person. But those are what we refer to as the supporting documents, is just what's required under the law to expunge adult convictions.
Perfect. Can someone expunge a misdemeanor and a felony, assuming both are eligible for expunction? If they occurred in the same county, can you do those together?
No. So if they both are eligible, that's great. There are two separate forms for expunging adult misdemeanor convictions and adult felony convictions. And so even if it's in the same county, in the same court division, you would still file two separate petitions just purely because one would be a misdemeanor and one would be a felony. So when it comes to adult convictions, not only do they have to be, same county, same court division, they also have to be misdemeanors and then felonies on the separate form as well.
After an expunction has been granted, at least I think this is what this question is asking. After an expunction has been granted, how long does it take for, I guess, that to be processed throughout the system for no longer to be publicly available?
Yes, great question. That is going to depend, but essentially, when somebody receives the granted order back from the court, it should have the clerk's signature on the back page, and that signature is essentially the clerk certifying that they executed the expunction. So at that point, if the clerk followed through and was able to execute it appropriately, if that person were to go online and go to the NC Courts portal, search and type in that case number, it should no longer appear. And so, pretty much most of the time, once somebody has gotten the expunction order, it should no longer be appearing in that public record search. But of course, if it was on somebody's SBI, State Bureau of Investigation record, they tend to be a couple of months behind on executing expunction orders. But again, it's not like I could, you know, people are requesting people's SBIs like that to be able to see. And then third party background check companies, they don't always use updated data. So people may find that expunged charges and convictions may still appear on third party background check companies. But if that is the case, you do have rights to be able to get them to execute it and remove those expunged offenses.
Got you. Oh, I think this is a follow-up to the question before that about the felony and the misdemeanor. If
Yep.
they are separate petition, can you file both the petitions at the same time, even if they can't all be filed on the same petition?
if if they were both currently eligible, depending on
Hmm.
the wait period, then
Hmm.
yes, theoretically that is possible. I've done it before for several clients. If they're eligible, then you can file all of it at the same time, pretty much everything that person's eligible for, so long as they meet the requirements under the law.
Perfect. And then, not sure if you can respond to this question. But someone's asking if something is expunged like a felony, does that mean it also restores certain rights, such as maybe rights under something like the Second Amendment? If you cannot respond to that, no problem.
Yeah, I can't respond to that.
Perfect. Okay. Oh, okay. Good question.
Mm,
Someone's asking about not the public forums, but things like maybe Facebook pages or other
mm,
um,
mm-hmm.
that keep like mugshots and
Yep,
things. How do you, is there a way to go about getting those to take down someone's picture
yep,
and information after charges have been dismissed or
mm-hmm.
um expunged or something? What happens to those records?
Yeah, that is a great question, and it's actually a pretty difficult subject in terms of that, because really when it comes to expunction, it is just a public record, public court record. And so um really I don't think like Facebook or some of these like newspaper articles that run mugshots when somebody is initially arrested, even, no matter what the disposition ends up being, I don't believe that they are obligated to remove those. And so in certain circumstances, I would say the best, what I might recommend is that if somebody has an expunction order, is reach out to that particular entity themselves and, explain the situation and ask if they can remove reference to that charge, given that it was expunged. But unfortunately, I don't think there's any real enforcement mechanism unless it is like a state entity like the sheriff's office or anything like that, or, the police department. Um, some of these third party, websites, I don't believe I have any obligation to remove those, unfortunately. Doesn't mean that they wouldn't, if they were to be aware of it, but I don't think they have any obligation to, unfortunately. So that's an unfortunate thing about the internet and, it being so widely available these days, is things like that can often happen.
Gotcha. For those asking questions about the application process for legal aid, we're going to get to that in just a second. I have some people are asking about those ineligible charges,
Mhm.
those convictions that make someone ineligible
Mhm.
to expunge any of their adult convictions. I did put a link to a statute that was
Perfect.
discussed in the video, but if you could just kind of quickly go back over that and also in that address assault once more.
Yep.
I think that would be helpful.
Absolutely. Sure. So essentially, in the statute that Marissa put in the chat, that is the statute that, governs expunction eligibility as it relates to adult convictions, which are just convictions that occurred when someone was 18 years of age or older at the time. And so the very first thing that, if you're able to click on the statute, you will see is a little section that really has just a bunch of other statutes. But essentially that little block at the beginning is what types of convictions would disqualify someone from expunging any of their adult convictions. So it only takes one of those types of convictions to disqualify someone from expunging any of their adult convictions. So, I think of it as like a poison pill. Like it only takes one of those, even if everything else on the record isn't one of those types of convictions, that those convictions will remain on that person's record. And so the most common ones that we see are Class A through G felonies, Class A1 misdemeanors. So that's like DVPO violations, misdemeanor child abuse, things like that. Um, Convictions where assault is an essential element of the offense. And again, really the most common ones we see have the word assault in the name of the offense, so it's not hard to kind of spot those. Um, there have been very few instances where, like, on the face of the offense, it doesn't say assault, but then we look into the law and we look at the actual elements, and then we see that it may or may not have assault as an element of that offense. But most of the time, there's really no question if it says assault in the name, that is going to be disqualifying. And so those are the most common ones we see, along with felony convictions for involving methamphetamines or heroin. No matter what it is, it can be mere possession of those types of drugs. Whereas for cocaine, there needs to be some kind of further intent. So selling, or delivering, or possession with intent to sell and deliver, those are disqualifying, but mere felony possession of cocaine is not. And so essentially, like I mentioned before, it is just a list of convictions that will stop somebody from expunging any of their other adult convictions if they have one of those types. Um, and so hopefully that was helpful. And was there another part to that question that I missed?
No, no, I think you got it all.
Okay, great.
And then hold on. Okay, okay. Um, Not sure if you can respond to this next one.
Okay,
If you can't, no problem.
sure.
For a conviction that has a 10-year wait period, but I guess something called the Second Chance Act wait period of 5 years for non-violent charges, would that change that wait period? Not sure if you're familiar with any of that.
I Those are words like that I know, but
Okay,
I don't think in the way that the question is asked that I understand what they're asking.
perfect. No
Yeah.
problem.
hmm
Um, have you ever experienced circumstances where something that was eligible to be expunged was not expunged?
Typically, no. Expunction law is very statute. It's very statute specific. Like the statutes, they are wordy, but they are very clear about what is or is not eligible to be expunged. And so most of the time, as we're reviewing records, we're determining eligibility, we're looking directly at the statute. And so there's not really much wiggle room to, kind of argue that one thing should be eligible or not. Like the law is very clear. If this, then not eligible. If that, then eligible, depending on the wait periods and whether you've satisfied all of the other requirements by law. And so most of the time, if not 99.9% of the time, if we as in legal aid are reviewing a file, are filing the petitions for a client, we believe that under the law they meet the requirements, and it tends to be that is the case, and they get granted. And so the only time where that might not be the case is felony convictions under the law are technically discretionary. And so even if somebody is eligible based on the statute to expunge their felony convictions, adult convictions, the judge has discretion as to whether they grant the expunction or not. And so in my about 3.5, almost 4 years of practice doing expunction work, that's not something that I've seen very often. But ultimately, judges can use their discretion as to whether to grant or deny felony expunction of adult felony convictions, even if the petitioner meets all the statutory requirements. Um, Expunging adult misdemeanors is mandatory though, and so if somebody has adult misdemeanors that they are expunging, if they meet all the requirements, and the judge doesn't have discretion then. So that really only comes into play with felony convictions or certain dismissed charges where somebody was convicted of an offense at the same time. But that's not something I have seen personally too often, but it is possible.
Gotcha. And by chance, do you know if that statute that you mentioned, does that have the wait periods? Or what statute has the wait periods?
145.5, which is the one that you put in the chat, has everything that someone would need to know about eligibility in terms of expunging their adult convictions. So it covers all of that.
Perfect. So for those asking about wait
hmm
times, take a look at that statute. And then got a couple of people asking, I'm assuming they're asking, does legal aid have
hmm
any in-person expunction clinics coming up anytime soon?
We do not have any in-person expunction clinics coming up anytime soon. I would say if you're most of our work is done over the phone, mainly because we are a statewide project. And so we're based out of one office, but we take clients from all 100 counties across the state. And so a lot of our work is done with our clients over the phone, through email, things like that. And really the best way I think to get help would be just to apply online through the Justice Hub. And, if we're able to help, we will do whatever we're able to at that point, depending on the case. But I know we've done that in the past, but right now we don't have any in particular coming up.
Perfect. Okay. Don't think I'm seeing any other questions aside. The questions asking about eligibility for legal aid, I will respond to those in just a moment.
Perfect.
Gonna give just a second. I do see some raised hands. Again, if you have a question, you need to type it into the Q&A box. And we're gonna wait just a second, and then I'm gonna address those legal aid eligibility questions. Um, okay. So first one, because I can't respond to this one. Someone is saying I'm assuming that their convictions or charges or what have you are in North Carolina, but they don't live in the state of North Carolina. Would
Hmm.
that be something legal aid could potentially help with if they otherwise qualify for services?
Yes, so that shouldn't be a problem. Really, what would be determinative is that expunction law is state specific. So if somebody lived in North Carolina and had out of state charges, we would not be able to help with those because we only practice North Carolina law, only licensed in North Carolina. But if somebody lives elsewhere now but has a criminal record in North Carolina, and they qualify for services otherwise, we would be able to take a look and kind of see what's going on there. So that shouldn't be an issue.
Gotcha. And if you are experiencing that issue, please put that in the Q&A box and I will pass that along to our Justice Hub people if that is showing up where you're not allowed to apply for
Mm,
services.
right. That's a good point.
Um,
Yep.
oh, new question.
Hmm.
Can an expunction be filed online or do you have to go to the courthouse to turn in your paperwork?
You, as attorneys, we are required to use the e-filing system, and I do believe that pro se individuals, pro se meaning people filing on their own behalf, can use the system. Um, and so there is a possibility that someone could petition to file electronically, but if you're filing on your own behalf, then there is also the option to mail it in as well.
Perfect. Doing one last check really quickly. Checking Facebook one last time. All right. Now I'm going to respond to there are income requirements. Someone's asking about eligibility for legal aid. Legal aid does have income and asset requirements. Um, they are determined by household income, which is usually determined by gross income, so not net, which is the money someone brings home. It is the actual gross amount that legal aid usually determines eligibility on, and it is by household income and household size. So to be eligible for legal aid services, someone would need to be both income and asset eligible in most cases. Um, the best way to figure out is that when you go onto the Justice Hub portal, you're able to do a pre-screen, and a lot of that pre-screen kind of goes you through some of those initial income questions. You could probably get a better sense of whether or not you might qualify under our income eligibility guidelines. Uh, oh, well, here's a new question.
Yep.
For an offense that was a couple decades ago and someone has called the court and the court is saying they don't have a record of it, how does that person obtain a copy of that record? That's a new one.
Yep. And that unfortunately does not have a straightforward answer to it, because we have come across that in some situations as well, where, you know, I think they only imported records like electronically into the like online record keeping system only as far back as like maybe the early 80s, maybe not in all cases, depending on the county, I think. And so a lot of times if somebody has records that are older than that, they won't appear in the public record database search, even though they probably do exist somewhere. And you can likely find record of them, like brief record of them on other um, searches, like Department of Adult Corrections. If somebody went to prison or did some kind of probation for that charge, it likely is on there. And so a lot of times what we have had to do is go into the archive books of that county and try to find the records there. Now, I'm not sure if that's something a pro se individual would be able to do, but it might be worth asking the clerk if that is something that they have access to and if they might be able to find it. Um, and that's not a straightforward answer because it really does depend on the county, but that is possible, and there may be a way that they have record of it, just not electronically.
Perfect. And last question I'm seeing here is, does an expunction reopen a case? I think that is, yeah.
No, it does not.
Okay.
So a case has to be disposed, meaning it was resolved, so it doesn't reopen it in terms of like being able to like relitigate the case or anything like that. No.
Okay. Perfection. As I am not seeing any other questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you to Lorena for, she was the star of our video, as well as for answering all of those questions. If you would like to review anything from the video or any of the questions that Lorena responded to today, a recording of today's event will be posted to our Facebook page. It will be immediately available following the event. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other listen and learn clinics, such as child custody, tenant rights, simple divorce, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.
Thank you.